Welcome back. In San Francisco, the tech community is anxiously watching how some high-profile legal cases concerning artificial intelligence are playing out. Most of them target OpenAI and Meta for its AI chatbots that use internet data to train. Mark New explains.
Comedian Sarah Silverman, along with several authors including Christopher Golden and Richard Kadri, accuse OpenAI and Facebook of ingesting their copyrighted work without permission and without credit. But last week in the case of OpenAI, the judge dismissed 4 of the authors' 6 claims. The judge said they failed to explain that any OpenAI language model output is substantially similar to their books.
Difficult to prove that OpenAI's tool, purposefully and intentionally, and that's the key word, tried to infringe or copy her works. But with respect to this case, it's more difficult because we're talking about a generative AI solution that has no feelings.
But technology lawyer Levy points out that 2 of the author's key claims remain, whether OpenAI directly copied or distributed the plaintiff's works, and whether OpenAI engaged in unfair business practices.
I definitely don't think there's any kind of argument to be made here that Silverman in any way is losing or winning. I think that any infringement claim is a pretty big claim that carries some significant legal risk and repercussions.
Similar cases continue to build, including a lawsuit from novelists including John Grisham and a Game of Thrones author, George R.R. Martin. They accuse OpenAI of systematic theft on a mass scale.
On the one hand, you want to ensure that innovation can continue uninhibited in the growth of new technologies. At the same time, you want to protect people's rights as they are entitled and protected to by law. But obviously, technology is advancing faster than laws can.
And in yet another lawsuit, the New York Times is currently suing OpenAI and Microsoft. The media outlet has been able to do something the Silverman team has been unable to do: provide evidence that chatbots are churning out its articles word for word. The New York Times also accuses the chatbots of incorrectly attributing misinformation to its publication in a way that's damaging its reputation. Mark New, CGTN, San Francisco.
Okay, this is complex. So joining us to add more insight and explain about AI and copyright laws is Pooja Nair, a partner at Irvin Cohen and Jessup. Pooja, welcome. Thanks very much. I want to kind of get right to it. A slew of lawsuits, as we just heard. Break it down for us in terms of really what's the main issue here. Taking information to train the AI so then it can pass on information to people who want to use artificial intelligence. Is that it?
Yeah, that's the main issue. And the main question and the main defense that's at issue is whether using those copyrighted materials transforms them within the fair use doctrine. So under the law, there's a fair use doctrine where it's an exception to copyright. So if you have copyrighted information, but you're using it for something like research or teaching purposes, or your use of the copyrighted information is transformative, then that's been considered a fair use. And that was really laid out in the Napster case back in 2001. But the question now is because these are some novel issues in copyright law, and so in the 2 sets of cases in the Northern District of California and the Southern District of New York, the real question is whether the OpenAI or Meta's use of training set copyrighted material falls within fair use.
I actually read a lot, and now as I kind of say it out loud, I wonder why I didn't go to chatbot and say, are you violating the law? Maybe I would have gotten a simple answer out of there. But one thing that I did hear time and time again was, look, if you're reviewing a book or if you're reading something and then going to pass that information along to a class, is that a copyright infringement? But really what comedian Silverman and many others are filing a lawsuit over is much different, a big game changer if these go through and Silverman is successful.
Yeah, exactly. And I think the frustrating thing for a lot of people watching this is how long the legal process takes. So, and we're really at the beginning of the stages, because from actually filing a complaint to getting the definitive ruling on these complex issues of law, it's going to take a long time. And so here we're really at the stage where the court is still deciding what pleadings and what claims are at issue, and that's where the motion to dismiss part is. It's very early on, and so there will be other chances going forward in the next several in the next months for the court to make a decision either on a motion for summary judgment or a ruling on the whole case on these substantive issues of law. But right now, what's happening in these cases is that the judge is essentially determining what are the legal issues that should be at play.
Okay, we're showing the New York Times right now, and their lawsuit is much different because they're basically competing with AI. So they can say, look, we've been adversely affected because people can go to AI and they're taking our information and artificial intelligence and AI passing it off basically as its own.
Yeah, and I think some of the evidence that they've showed and the fact that the New York Times case also names Microsoft's tool, and Microsoft has something that's competing with the New York Times, and similar language from those articles is coming out, because one of the factors in evaluating fair use is the effect of the use of the work on the market for that work. And so if someone's not a direct competitor, they can't really meet that prong. But the New York Times, I do agree, that's a different lawsuit, and it's an important factor for the court to consider in terms of determining whether it's fair use or not.
Okay, for people out there wondering, why didn't all sides sit down and try to hash out something? Well, they did try, and it simply didn't work. And I think one part of that is policy and laws are simply not keeping up with AI development. It's just coming too fast.
I agree. And I also think that the fact that there's a slew of lawsuits at the district court level is going to mean ultimately that several years down the line, the Supreme Court is going to have to make some of these decisions, because there is a high risk of inconsistent rulings. While there's clear factors under fair use, different courts at the district level, which is what's deciding now, could come out in different ways. Whereas you might have someone saying that this is a fair use and something very similar in a different in a different state is not fair use, and so that'll then go up. So I imagine that these cases will go up on appeal, and then if the different appellate courts, for example, if the Ninth Circuit, which is where California is, and the Second Circuit, where New York is, if they have different interpretations of the fair use law, it will create a conflict that needs to be resolved ultimately by the Supreme Court. So I could very easily see that happening. So I think that it may be an unsettled area of law for quite a while to come.
Pooja, let's talk about some of the main defenses that AI companies are leaning on right now in these lawsuits. You did mention fair use just a second ago, and I'd like you to expand on that just a bit if you could.
Yeah, sure. So the fair use doctrine is the main defense. And I think that's what, if you look at what OpenAI put out in response to the New York Times lawsuit, that's really what they're leaning on. And that's the idea that there's a copyright exception. So even though a work may properly be copyrighted, people can still use it for teaching, for research, or if there's a transformative use, meaning that if what you take from the copyrighted work is and what the product you come out with is different, if it's substantively transformed, then that could still be a fair use. So there's 4 factors that courts will look at, and that includes the portion of the work that's actually used and the effect on a potential market, and it's kind of a case-by-case question as to whether it's fair use or not. But ultimately, that's the core of the defense that all of these AI companies are leaning on.
Okay, Pooja, it may be an unfair question. In fact, I'm probably pretty sure it's an unfair question. I don't need AI for that one. But I'm going to ask you to give me your best analysis on how you think these lawsuits are going to play out and how it is going to be resolved. And it's very difficult to put the genie back in the bottle.
It's very difficult to put the genie back in the bottle, and I think that I actually have a strong feeling that there are going to be inconsistent results in some of these cases, because the fair use doctrine leaves a lot to the judge to determine how the four factors apply. And so I could see the New York Times case coming out with a different outcome than some of these author cases on the training materials, because to me, the cases where copyrighted books are being used for the large language model training set is kind of more similar to the context of research or teaching at a university, and the product coming out is not going to be an exact duplicate of the work of the authors, right?
Yeah.
You put that into the model, but you're never going to get something exact out. But I think that the examples and the evidence that the New York Times case has is a little bit different. And so, I'm not the judge on the cases, but I would not be surprised at all, and I would expect that there's going to be some conflicts at the district court level where different judges are coming out differently. And I do think that in maybe 3-4 years, we'll have a situation where the Supreme Court needs to weigh in.
Wow.